Far too often, the person contacting you will describe elements of the case, then ask you what you think or whether you're interested in the case. At this point, neither one of you knows the answer. You both have to ask additional questions before you agree to take on a case and/or they agree to hire you. Attorneys always ask about possible conflicts of interest. Any relationship with a law firm involved in the case or a person involved in the case would constitute a conflict of interest. If no conflicts exist, you should assess then whether you have the time to take on the case. If you are a busy consultant, you may not have the time to fit a new case into your existing schedule. On the flip side of this same coin, you should ask the attorney about any known scheduling for the case. For example, are there firm dates? Are they flexible? Are there dates for the close of discovery? Are depositions already underway or scheduled? Is there a trial date? And if so, what is the projected duration of the trial? Conflicts of interest and conflicts of time are both unfortunate reasons for not being able to take on an otherwise interesting or desirable case. The job of an expert witness is a demanding and sometimes grueling exercise. Ideally, you want to take on cases that are satisfying and rewarding. If you like your expert witness work, you will have your heart in it, and you will be a better witness. The decision to reject a case is ultimately yours completely. Various reasons exist for rejecting cases, and you can always express your rejection politely. You can tell the attorney that you are sorry you cannot take the case on, and then explain why. You can also offer, and this is a good idea, to put them in contact with another colleague or expert who might be able to help them in this case. You should have in advance prepared the names and phone numbers of one or two other experts to whom you can refer occasional callers. Referring attorneys to other experts generates goodwill and may lead to new business from the attorney and actually the other expert as well, either of whom may appreciate the referral and at times need to refer someone else to you in the future. The biggest and first reason you should reject a case is if in good conscience you do not think that you are qualified for the case. You may not believe that you have the appropriate experience and skills to do the investigation, analysis, or tests for the case. Since you will eventually have to defend any opinions that you form from this work, you should be confident that you have the right credentials and skills for doing the work. On the other hand, you just might not like the sound of the attorney on the other end of the line. You might not like his attitude, or you might conclude a lack of professionalism in his probable approach to the case. I've had attorneys call me the week before a trial and ask me if they could hire me to give testimony in the trial. I've had attorneys call me the month before the submission date for expert reports to ask me to perform an entire investigation and analysis and writing of the report. A month may sound reasonable to you. The attorney in that case told me that the other side had hired their expert a year earlier, and the expert had been working on his report for nearly 9 months before finally completing it. If you do not have the time to do the job properly, you will suffer when you are unable to present a credible expert analysis and a defensible expert testimony. So an incredibly important tactic for you is to not accept a case with a timeline so tight that you will not have the time to do the job right. I know expert witnesses who do not accept any defense cases that have to do with child pornography. I know other expert witnesses whose certifying organizations forbid their members from taking on any defense cases. Some expert witnesses will not take on a case if they think their side will lose. They simply do not want their own reputation hurt by a losing verdict. In my experience, you are more likely to be on the losing side of a case if you work with attorneys who are dishonest or incompetent. However, you may judge that for yourself. You cannot always recognize these characteristics right away. If you can identify an attorney as incompetent or unethical, that alone should justify rejecting the case. Unfortunately, you may discover the attorney's incompetence much too late in the legal process. You can become suspicious if attorneys are unresponsive to your questions or needs in the case. When attorneys discount the importance of steps you suggest or documents that you feel should be considered, you'll begin to suspect a problem. Sometimes you can only confirm your suspicions after the case ends and after the clients sue the attorney for malpractice, as I have seen with multiple attorneys. I did not enjoy working with those attorneys during the case. I'm not a lawyer, so the times when I've wondered about the skills of attorneys during the process are times that usually turned into losing cases. Identifying those attorneys in the beginning could have guided me to reject any casework with them. Fortunately, you can do that in advance in a way that I did not realize existed earlier in my career. The Martindale-Hubbell Peer Review Ratings offers a service for any person seeking to hire an attorney. You can use this service to help you determine whether an attorney is ethical and has a good track record. On the internet, look up Peer Review Ratings Service at martindale.com, which will provide you with information about virtually every attorney in the country. As a tactic, then, to learn about the performance track record of attorneys, use this peer review opportunity at martindale.com.